Hello again, hope you're all doing well, and Happy New Year. And what better way to kick off the new year than with the ever popular 50/50 Parenting Time Roundup, where I cover the good, the bad, and the dramatical. But first, for those wondering what's going on with that attorney fee CLE that you were hyping up the last couple of months, it's actually online right now. Last week I uploaded a free preview. I'm working with the MCLE people on getting it accredited. I can't promise anything, but I'll update the Substack when I know where things are going. So please, for those interested in it, just treat it like a glorified lecture on defending fee petitions in family law cases. Yes, it's $40. It's the only time I charge for anything, and all the proceeds go to CVLS. It's a great legal aid charity. So please consider it, and the fundraiser runs through February 1st of 2026. Anyway, this year, well, we just started this year, but last year was the year of drama. 2 of the 11 featured cases involved parental rights advocates. If you sense some disdain in my voice, it's because, in my view, most parental rights advocates are neither. And I'm not talking about the Mark Ludwigs or the Robert Garzas. I'm talking about the clowns who obsessively broadcast their personal drama on social media under the pretense of reform. Because once you hear these guys rant and rave long enough, it's pretty clear it has nothing to do with parental rights, except to the extent that it might give them an excuse to be a little bit more abusive in the future. An advocate is just a label they give themselves with a lot of freety, if you will, to justify acting like a complete spoiled brat. So I'm glad we've had 2 of these come through the appellate pipeline, and I hope it will convince someone after they read these decisions not to act like an asshat for some TikTok views. In the case of Nelson, Dad ran both a TikTok and Facebook page, did a lot of bragging about his ratings and how many people were, I guess, tuning in to his drama. Turns out, however, the kids, which he claimed to care so much about, well, they were getting teased about their dad's crazy videos at school. The opinion, it gets worse, man. The opinion further indicates Dad would call his daughter, I'm not going to say it. Here it is. And I'm not giving either of these clowns any advertisement. I'm not posting links to their socials. But I will feature the other advocate case. It's Weston. The person in question, mom, was a recluse who locked herself in a room and filed nonstop motions and other stuff. According to the written decision, the parties were pretty high conflict. Apparently, they couldn't even work out who got Mother's or Father's Day, which, man, it's almost like you're trying not to work together. There was also testimony that mom fled the scene of a high-speed accident. Allegations, actually, it seems that were more than just allegations, that she had some history with alcohol and drugs or prescriptions or whatever. You know, from the GAL's viewpoint, mom had impulse control problems. I'll just say this. When you crash out repeatedly on the record during a court hearing, you've made life pretty easy for the other side. Anyways, in both cases, the court told the advocates to go pound sand, and the appellate court affirms in both instances. Here's the moral here. If you want to win, you keep your drama off Facebook unless you want it to be Exhibit 1, 2, and 3 in the other side's case in chief against you. All right, I'm off that one. Moving on, I've included a nifty guide. It has divided the cases into 3 categories, where 50/50 was granted, where it was denied, and the miscellaneous section. Notice in just about every single case where you have 50/50 awarded, conflict meter is baby blue. That means low. And where it's denied, it's red for high. And every year when I do these roundups, and I've been doing 50/50 roundups since 2021, but every year I always bring out my one-hit wonder appeal. In remarriage a virgin. It's the come on Eileen of my practice, because I was appellate's counsel. I got a very fortunate reversal, and until the appellate court finds a better example, it remains Illinois' leading case on shared parenting. And in virgin, it was a very high conflict case. 50/50 was reversed. So far, that streak of no 50/50 when there's high conflict has lasted nearly 5 years, and that streak remains unbroken for this latest edition. But, and there's always a but, we had a close call in the John Wayne District. The John Wayne District is, I call that the 5th. Or maybe I should say I call it John Wayne because the 5th is really a lot like the Duke.
Wait a minute, I didn't do anything.
You should have.
And I really hope the 5th has a good sense of humor there. Anyways, They issued a shot across the bow in McLean. In McLean, there was an award of 50-50 in large part because the parties were actually moderate conflict. It wasn't high, it definitely wasn't low. And the idea in awarding 50-50, according to at least one of the expert witnesses, was to create a checks and balances system that by giving each parent an equal share, it prevented the other from cutting the other out of the children's lives. Interestingly, it seems the fifth isn't the only district looking at this theory of checks and balances. You turn to the third, in another case of mine, Gore. This is really quickly turned into a very bad advertisement, but in one of the issues in Gore was whether 50-50 was prohibited in a moderate to high conflict case. And the third didn't actually reach that issue, but in closing on the last page of the decision, they issued this very chilling observation. It says, the court's decision to maintain the joint decision-making as a, quote, checks and balances, end quote, against the parties was consistent with the GL's recommendation and may be in the parties' children's best interests. Whew.
Fasten your seatbelts. It's going to be a bumpy night.
That might be good advice because we could be seeing a lot more parents run into court in moderate conflict cases and argue they should get 50-50 under the McLean's checks and balances system. So stay tuned for that one. Another interesting case in the roundup is Knight. It's interesting because it dealt with a parent who took accountability. In Knight, mom had issues. DCFS had even gotten involved at one point. But instead of doing the classic, it's never my fault, especially when it is routine that we see so often in those types of cases, mom pulled a shocker. She took accountability, went to therapy, did what she was supposed to do. And the appellate court reversed a denial for her request for 50-50. Parents, you want to shut down a case and you're the parent with maybe some rough edges? Take accountability. It's attorney kryptonite because we have nothing to throw at you when you do that. I'm deadly serious. Yeah, I did. I'm sorry. I'm going to AA. Oh, I'm going to a therapist. I apologize. I made restitution. You know, when you do that, that's telling the judge, I'm getting with the program. I'm taking this seriously. Can you please cut me some slack? And I hate to give away trade secrets. Most judges will cut you slack when you genuinely fall on your sword. Let me say this again differently. Too many parents who make dumb mistakes. It's not the mistake that does them in. It's when they double down on it. That always causes their undoing. You get a DUI. Oh, no, I don't have a drinking issue. You threaten a jail. Oh, it was just words. I didn't really mean it. You file a bunch of crazy lawsuits that get tossed. Oh, no, I'm not high conflict or vexatious. I just tripped and fell, and they just ended up in the e-docket or pacer system. You remember that crazy viral video from a few years ago? I'm going to close with this, where the ladies would win a $100,000 prize if they took accountability. It's a skit, guys. Just relax. And by taking it, that's all they literally had to do, just pick up the word.
It's over with.
Look, it's funny. Just laugh. Laugh as a joke, okay? Men do dumb stuff too.
If you can't find what you're looking for in a store, don't ask for help. Walk out. Be a man.
My overall point, low conflict is the best setting for 50-50. Here's some examples. Lang, parties had 50-50 temporary schedule while the divorce is pending. And oftentimes in family law, there's nothing more permanent than a temporary order. But, here the parties had done very well for the last 2 years leading up to the custody trial. There was no drama with their 50-50 schedule. So the 50-50 was made the permanent order. Yeah, another case, Warren. Mom moved closer to the kids. Case was low drama. Wants and gets 50-50. This is not rocket science, folks. You don't need to hire an $800 an hour attorney to get 50-50. You just got to keep the Telemundo stuff out of court. All right, final case for today. Tiffany A. And I feature it because, that one, Dad was asking for 50-50, but he actually ended up getting the whole enchilada. Mom was not really very cool with that, so she appealed, and it's her trial strategy is why I'm featuring it. She's arguing the GAL was just the worst GAL in the world. Just ask her. Tiffany A. is a great example on how not to attack a GAL in court. Rookie mistakes through and through. Where she's asking, oh, why didn't the GAL do this? Why didn't they talk to that person? And I appreciate that the appellate court took a few paragraphs in this decision to explain to lawyers and maybe even pro se parents that tactic is not how you prove the GAL report is trash. How you prove it's trash is by subpoenaing the teachers, cops, staff, DCFS caseworker, counselors, doctors, and everyone else who has no reason to lie. Yeah, you can bring in your roommate or your mom or whoever, Honestly, everyone knows that if the roomie says something that hurts your case, or your mom says something that hurts your case, they got to deal with you in your stink eye after the case is over. So no surprise, they're going to say you're super cool. Shock alert here. Most judges expect that kind of testimony to come out. It doesn't really move the needle. But third parties, man, if they got no dog in the fight and they testify to big ticket issues that the GAL should have caught, that is almost always going to sink their report. Let me repeat this for those in the back. You hate your GAL, let's say, and you want to sink their case. It is simple. You get the third parties who have no dog in the fight, and they testify to big ticket issues. Mom, in this appeal, was running to the Galandi decision. That's that infamous JL case where the kids were literally living in filth. The place, as you look at it, was uninhabitable by even the GL's own testimony. And that GL was like, not my problem. Well, probably not like that, but the GL didn't seem super concerned about it. The facts in that one were catastrophically bad. Mom misses the point of Galandi. That case, it was just really extreme. Here, Mom was just saying, oh, the GAL could have done this, or maybe they should have done that, or whatever. But she never brought in the reliable third parties to take the stand, the cop, the doctor, the counselor, to corroborate her claims of what reality may or may not have been. So the appellate court tosses her appeal. Speculation about what could have been done or who could have been talked to isn't the same as bringing in the witness who says X or Y happened, and those witnesses have no reason or incentive to back either parent. Those sink GAL recommendations. So read this case. It's a great how-to on attacking a GAL report. Anyways, before I round up, there are a couple cool nuggets in the Roundup magazine I put out, such as the conflict level. There's some notable facts to consider, maybe even some notable case law, if it's cited to it in the decision. All of this is done in under 10 pages, and as always, it's cheap as free on the Substack, so maybe consider subscribing if you want to get notified when new freebies drop. And finally, if you want the mother of all CLEs, well, to be fair, it's being submitted for CLE credits, so who knows what's going to happen with that. But if you really want a great 52-minute lecture on defending insane attorney fees in family law cases, also comes with a guide with like 70 some odd cases in it. The link is below. Yeah, it's $40, but your lawyers, you can afford it, and proceeds go to CVLS, so don't be a cheapie. As I mentioned earlier, the fundraiser runs until February 1st, so maybe hurry. Anyways, it's all I have in this longer than usual video. I'm back at the end of February or maybe middle of February with a Valentine's Day special. No idea what the topic will be. It will certainly be very apropos for the holiday. Hopefully it will also be good. Anyways, until next time, as always, thanks for watching.